inviting me, and it's so nice to be in the. We invited. If we had a similar event at IIT, first of all, assuming it was, it was passed or accepted, my fear would be we be able to fill a room this size? So I'm glad that to be in a space where one doesn't have that fear. I enjoyed the book very much. One of the strange things I always find about book discussions is that one's discussing it before an audience which hasn't, perhaps read the book. So I'll maybe make a couple of comments about the book as I read it. I don't have that much to say about, about citizenship studies per se. So what I thought I'd do is I'd say a little bit in my comments about the place in the debate for discussions of the Constitution, particularly the 1950 Constitution, the way it plays out as I see it in the book itself, and more broadly in discussions about the about the current moment in connection with citizenship. So the first point, one of the things that Professor Roy does, right? She says she wants to chart a kind of a history of what she calls the three different citizenship regimes, and the first regime being, broadly speaking, in tune with the Constitution and its vision in the 50s. One interruption of that regime in the case of Assam in the mid-80s, the Assam Accord, and then this contemporary regime, which she says comes out of these, as she just said, two strands that come out of the 2003 Constitution Amendment Act. Right? And one of the broad themes of the book is that the citizenship regime in India overall has gone from this more inclusive kind of regime to the current majoritarian one. And the first point I wanted to make is just actually methodological. And so most of her work, and the ethnography, it's much more textured and detailed when it comes to the present. And I think that and I guess my question is, if one looked at the debates in the 50s at the same level of granularity, so the work that the 50s do in the book, by and large, I think it's in a couple of different places reference to the Constituent Assembly debates, and that's taken as the site for where the citizenship, where one can read the citizenship regime. But I think that perhaps gives us a much rosier picture for that citizenship regime than one would get if one looked at things in a more messy way. Right? In the same kind of way as, for instance, if the contemporary citizenship regime one only looked at the Rajya Sabha debates or the JPC, right? One wouldn't see the depth of contestation around these issues. And I fear that perhaps, or at least raise the possibility that might be what's going on in the 50s. And if you look at, for instance, at Joya Chatterjee's work on the Bengal partition, you get a much more complicated and troubling picture of, again, what's ostensibly this great Republican moment, but the way it actually plays out in practice, it's quite majoritarian in parts. I was just looking at one of the acts that you point out, in fact, in the book, which I hadn't heard of, the Immigrants Expulsion from Assam Act of 1950. So that's March 1950, and that's quite, even on its face, I think majoritarian. One of the things that Professor Roy talks about is how, there is this debate in the Constituent Assembly, and people are essentially, one of the things people are getting upset about is how to think about citizenship to people who migrated from India after partition and now want to come back to India from Pakistan. And at least one section of the assembly is very upset at these people because these are people who quote unquote are traitors, or they've divested themselves of Indian citizenship when they left, and now if they want to come back, they should come back as foreigners. We'll give them citizenship, but don't treat them on par with the people either who stayed or the people who migrated, right? And there's this kind of the refugees are the good people who came in, from what is now Pakistan, and these people are people whose credentials one will doubt. And in fact, it's a very specific frame for one, and again, they can't say this, right? They can't say, or they don't say that, if you're Muslim, you're going to have a second-class status in as far as citizenship is concerned. But yeah,
there is a problem with the sound.
Oh, okay. Is this better?
Yeah.
Sorry, huh? So they can't on its face point to a religious exemption or a religious criteria for citizenship, but one of the members of the assembly says, let's make a distinction between people who have come because of the fear of civil disturbances and people who haven't, right? And that fear of civil disturbances is supposed to, again, let's say Hindus and Sikhs who are leaving the territory of Pakistan, it's okay for them to come because they're leaving out of fear, as opposed to people who are coming out of Pakistan who are not coming out of that sense of fear, and we're going to be suspicious of that. But this Immigrants Expulsion Act of Assam, that actually includes that language. So in the Constituent Assembly in 1949, that language is excluded, but it comes right back, the following year. And even if you think, there's a moment in the book, and I mean this is a part of what's going on in the assembly debates, where there's one member of the Constituent Assembly from Assam who says things that are maybe very familiar to people working on citizenship in Assam today. But one of the things that is interesting is Dr. Ambedkar has a response to him. So okay, the issue is essentially, again, what to make of this category of people who left India in the post-partition territory of India, went to Pakistan and want to come back. Should they be on the same status or not? What the Constitution does in Article 7 is, people who've left after March of 1947, they lose their citizenship, and if they get it back, that's only going to be if they get a permit. They have to get a permit for resettlement or permanent return. So there is this bureaucratic gatekeeping that comes in. And one of the things Dr. Ambedkar says, don't get too stressed about these people who you think of as infiltrators, etc., because that permit system, that's a real system, and those people are going to have the power to exclude the bad people and get them in. So even in that debate, I think we can tend to read in sort of our anti-majoritarian instincts into that assembly, but I think they're there, not far from the surface, and one has to just look a little bit more carefully to find them. At least that is one thought that struck me. So that's the first comment, which is a primarily methodological comment. The second comment has to do also with the way the discussion of this first regime of citizenship is framed around the deliberations of the Constituent Assembly. And again, one of the things that's very striking to me is how much heft the Assembly and the preamble and the Constitution have in these contemporary debates. I'll say a little bit more about that. But the way you characterize it, and it's I would say maybe a default characterization, right? It's essentially a deliberative body whose activity, it shouldn't seem as part of the exercise of normal politics. It's this is some kind of constitutional moment. It's above party politics. It's guided by some broader norms and goals. It's some kind of commitment to principle. And there's a lot of literature now, including I guess by some of it by Gautam, on this constitutional moment and what it tells us, and as something that we have to reclaim. But I wonder whether in fact the debates governing citizenship and the citizenship provisions in the 1950 Constitution perhaps don't quite match up to this kind of story, or perhaps when given a different story, I'll try and say why I think so. And I'm curious what one might say in response. And one of the things is, look, the topic, the actual discussion of citizenship is extremely limited in that moment, and it's limited in the sense that the debate begins with this acceptance order. And look, all we're going to do is talk about what does it mean to be an Indian citizen at the time the Constitution comes into force. Right? And this is now we're talking, I think, November of 1949. Is that August of 1949. So we're talking 6 months before the Constitution is coming to force. We now need to just get clear who's going to be a citizen. We're not going to talk about what citizenship is like in general. all those debates we're going to leave to Parliament later on. And the discussion is just introduced by Dr. Ambedkar and Rajendra Prasad saying that this has been one of the most contested issues. We've not been able to reach any kind of consensus on this, and so we're only going to focus on this particular question. And you think about, and by the way, that fact itself, for two ways, might trouble a kind of standard narrative one has of the Constitution, right? One is that this is a Constitution that's supposed to have these, putting in place this pedagogical enterprise for thinking about citizenship and for what it is like to be Indian, and has this kind of transformative vision. But again, the Constitution text is just about, okay, what is it to be a citizen after on 26th January 1950. So actually doesn't say anything about citizenship at all in any broad kind of way. Secondly, this is the dual part. It says we're going to leave all these decisions to Parliament. All the substantive debates about citizenship we'll leave for Parliament to resolve. And Professor Roy mentions that in fact the Joint Parliamentary Committee on the Citizenship Amendment Bill starts off from this idea that, look, the Constitution, you critics of the CAA, you're telling us that this is unconstitutional, but look, the Constitution says, Articles 10 and 11 of the Constitution give Parliament the clear authority to make these decisions, and we're just going ahead and carrying out or doing what the Constitution has explicitly given us the entitlement to do. And I think one can see that actually as a failure of the Constituent Assembly to precisely wall off by constitutional means questions about citizenship from majoritarian challenges. And so the fact that the Constitution chooses not to do that, I would say, is from my perspective maybe a strong mark against it. But at any event, I don't think it's consistent with this idea that we have this transformative moment. Again, just in this very limited context, and in the clause itself. So if you think of Article 6 of the Constitution, which governs the circumstances under which migrants from Pakistan can be citizens, there's a cut-off date, which is the 19th of July of 1948. Why is that cut-off date there? Well, that's very specific to, in fact, I have the name of what is it called? The Influx from West Pakistan Control Ordinance. So there is actually a permit system that's put in place on that date, and after that, the borders are no longer open. So you have in a constitutional text, which is supposed to be for, forever, you have actually a reference to a date that's enacted by a statute, or in fact an ordinance. So that again says that actually very local politics, very immediate political pressures are at play in deciding this constitutional text. And I just offer that possibility. There's an alumnus of your center whose work I like a lot, Arvind Govan. He has a kind of a general picture of the constitution making process at this time, which I'm very much sympathetic to. And he'd say, look, this just shows that this is this kind of extremely crazy political kind of space. People are trying to make compromises, just trying to figure out, how to manage, 6 months from now. This is not like, and so if one adopts that as the perspective from look at the citizenship text, then one maybe would also read less normatively from it. Professor Roy says, at the end, so it's true, Nehru at the end of this says, we're looking to put down matters of principle in the Constitution, and we'll leave the details for later. But I actually don't see what principles are actually set down by Articles 5 to 11 of the Constitution. I'm happy to have a discussion about it later. Yeah, how much time do I have? 3 minutes, 4 minutes. Okay. So let me make two final points, which are less about the material I've just said. One is, it does seem to me, in the context of even the current discussions around the CAA, so much of it is driven by questions about identity and majoritarianism, that there are other questions just having to do with due process, and just having to do the cruelty, even for somebody who ticks all the boxes, somebody who to get those papers at that time in this kind of period, and to establish your bona fides before a foreigners tribunal? Like, those questions are independent of the particular majoritarian aspect of that debate. But those have been there again since the start, right? This regime of documentation and the various points of the various bureaucratic chokeholds that allow you to get this kind of status, and that seems to be kind of unquestioned. In fact, 1946, the Foreigners Act, under which the foreigners tribunals are constituted, and which says the burden of proof is on somebody who's alleged to be a foreigner is reversed. You have to prove you're not. That's actually constituted in 1946 by the interim government. So I think that kind of due process consideration, frankly, I think is also something that's bad all the way through, as opposed to being good at one point and then bad now. And then the last thought, which is, I'd be very curious. It's not specific to the book or this topic, but it's very striking to me. This is how the weight that history plays in debates about citizenship or about politics in general. There is so much conversation about, okay, look, what does the Constitution say? What did our freedom fighters say? What did the quote unquote founding fathers say? I don't like these terms. And there's very little. So two things. There's very little there. So what do we want to be? we always talk about what we are. Even the response, the pro CAA material in the JPC is all about, okay, look, we need this now because the Nehru-Liaquat Pact failed, or there was this failure with partition. It's always referring to some historical injustice, and that seems to be like quite sad. Certainly people in the assembly, they weren't talking about we want this because this is the past. At least the most persuasive people speaking in the assembly on this issue were saying, look, tell us what is the kind of country you want to be, and that's what's going to determine what your citizenship should look like. Or you begin the book with this, the memory of Gandhi and Transvaal and those agitations, and those are also not agitations that are looking or resting their normative basis on the past. They're saying, look, this is unjust, this is not the way things should be, we want things to be another way. So I think actually we've lost something, and part of what we've lost, I suspect, is that in fact neither history of the nationalist movement nor constitutional history can actually bear the normative weight that we are now trying to place upon it. And and so I find that troubling. I think it'd be nice to have an articulation that's more forward looking. So with that, I'd say thank you again for your time.
Thank you so much.